Good day, everyone. I'm Ferdinand T. Sarasu Jr. and today I will discuss to you Article 1411, 1412, 1414, 1415, and 1416 of the Civil Code of the Philippines. Article 1411 states that when the nullity proceeds from the illegality of the cause or object of the contract and the act constitutes a criminal offense, both parties being in pari delicto, they shall have no action against each other and both shall be prosecuted. Moreover, the provisions of the Penal Code relative to the disposal of effects or instruments of a crime shall be applicable to the things or the price of the contract. This rule shall be applicable when only one of the parties is guilty, but the innocent one may claim what he has given and shall not be bound to comply with his promise. Rule on pari delicto. Generally, parties to a void agreement cannot expect the aid of the law. The court leave them as they are because they are deemed in pari delicto, or in equal fault. Pari delicto is a universal doctrine which holds that no action arises in equity or at law from an illegal contract. No suit can be maintained for its specific performance or to recover the property agreed to be sold or delivered, or money agreed to be paid or damages for its violation. And where the parties are in pari delicto, no affirmative relief of any kind will be given to one against the other. Indeed, one who seeks equity and justice must come to court with clear hands. This rule, however, is subject to exceptions, Article 1411 to 1419, that permit the return of that which may have been given under a void contract. For example, X, captain of a steamer, salvaged a burning vessel with its cargo by towing it to Manila. In an action against Y, the owner of the cargo to recover the salvage charges, the latter alleged as defense that the salvage was effected for the unlawful purpose of cooperating in the illegal importation of Mexican silver coins, then considered contraband, and that X previously agreed to transfer the same to his own ship and convey it to Apari. Y set up a counterclaim for part of the silver found missing. So the issue is X entitled to recover the salvage charges? The answer is yes. Salvage was something independent of the agreement to convey the silver to Apari and cannot, therefore, be affected by any defects which have vitiated the latter. The burning of the vessel was an accident unforeseen by Y, regarding which he had made no contract with X. Salvage was outside of the terms of the contract between them, which only referred to the transfer of the silver. In conveying the silver to Manila, X rendered possible the discovery of the contraband, which would otherwise have been avoided. Article 1412 states that if the act in which the unlawful or forbidden cause consists does not constitute a criminal offense, the following rules shall be observed. 1. When the fault is on the part of both contracting parties, neither may recover what he has given by virtue of the contract, or demand the performance of the other's undertaking. And 2. When only one of the contracting parties is at fault, he cannot recover what he has given by reason of the contract, or ask for the fulfillment of what has been promised him. The other who is not at fault may demand the return of what he has given without any obligation to comply with his promise. Rules where contract unlawful or forbidden but act not a criminal offense. 1. Where both parties in pari delicto. If the cause of the contract is unlawful or forbidden but there is no criminal offense, the rules are as follows. A. Neither party may recover what he has given by virtue of the contract. And B. Neither party may demand the performance of the other's undertaking. 2. Where only one party is guilty. If only one party is guilty, or both parties are not equally guilty, the following are the rules. A. The guilty party loses what he has given by reason of the contract. B. The guilty party cannot ask for the fulfillment of the other's undertaking. C. The innocent party may demand the return of what he has given. And D. The innocent party cannot be compelled to comply with this promise. 3. Where both parties are not guilty. If both parties have no fault or are not guilty, restoration of what was given by each of them to the other is in order. This is because the declaration of nullity of a contract, which is void ab initio, operates to restore things to the state and condition in which they were found before the execution thereof. For example, PHHC sold to S a lot subject to the condition that within the next 25 years from the date of sale, S would not resell the property except to PHHC. S subsequently mortgaged the property to Y, both parties being aware of the stipulated condition in favor of PHHC. So the issue is S entitled to invoke the breach of the condition? The answer is no. On the assumption that the mortgage and foreclosure sale violated the said condition, S and Y, as between themselves, were both in pari delicto, being participes communis, as it were in the wrongful transaction and being equally guilty, neither is entitled to complain against each other. Having entered into the transaction with open eyes and having benefited from it, said parties should be held in estoppel to assail and annul their own deliberate acts, since the condition is manifestly in favor of PHHC. Only PHHC is entitled to invoke its breach and not S. Article 1414 states that when money is paid or property delivered for an illegal purpose, the contract may be repudiated by one of the parties before the purpose has been accomplished, or before any damage has been caused to a third person. In such case, the courts may, if the public interest will thus be served, allow the party repudiating the contract to recover the money or property. Recovery where contract for an illegal purpose. Article 1414 is one instance when the law allows recovery by one of the parties, even though both of them have acted contrary to law. The following are the requisites for the application of this article. 1. The contract is for an illegal purpose. 2. The contract is repudiated before the purpose has been accomplished or before any damages has been caused to a third person. And 3. The court considers that public interest will be subserved by allowing recovery. The underlying reasons for the rule permitting a recovery when the agreement is still merely executory are the encouragement of the abandonment of illegal agreements and the prevention of the violation of the law. For example, Pedro agreed to invest his 1 million amount of money in the business of his friend of buy and sell. Later, Pedro discovered that it was a swindling syndicate. He therefore wasn't able to get his money from his friend. Pedro can sue his friend to return his money back to him. Article 1415 states that where one of the parties to an illegal contract is incapable of giving consent, the courts may, if the interest of justice so demands, allow recovery of money or property delivered by the incapacitated person. Recovery by an incapacitated person. This article is another exception to the in pari delicto rules in Article 1411 to 1412. Recovery can be allowed if one of the parties is incapacitated and the interest of justice so demands. It is not necessary that the illegal purpose has not been accomplished or that no damages has been caused to a third person. For example, if Hugo Layer is an insane person, the court may allow Hugo to recover the money paid if the interest of justice so demands. Article 1416 states that when the agreement is not illegal per se but is merely prohibited, and the prohibition by the law is designed for the protection of the plaintiff, he may, if public policy is thereby enhanced, recover what he has paid or delivered. Recovery where contract not illegal per se. Article 1416 is another exemption to the rule that where both parties are in pari delicto, they will be left where they are without relief. Recovery is permitted provided, number 1, the agreement is not illegal per se, but is merely prohibited. 2, the prohibition is designed for the protection of the plaintiff. And 3, public policy would be enhanced by allowing the plaintiff to recover what he has paid or delivered. Contract illegal per se and contract against public policy distinguish. An act or contract that is illegal per se is one that, by universally recognized standards, is inherently, or by its very nature, bad, improper, immoral, or contrary to good conscience. On the other hand, what is contrary to the public policy, like public interest, whether expressed in a constitution or in any statute or official declaration of the duly constituted authorities, or evinced from the situation or circumstances of the time concerned, is something dictated by the conditions obtaining within each country or nation. For example, S sold to be an agricultural land. Both are non-Christian Subanos, but S is illiterate and could not read and write, while B is literate and could read and write. Under the law, conveyances and encumbrances made by illiterate non-Christians shall not be valid unless duly approved by the provincial governor or his representative. Sale was approved by said official only 2 years after S filed a complaint for annulment, seeking to recover from B the land sold. Issue: is the rule on pari delicto applicable? The answer is no. S is not equally guilty. Conveyances by illiterate non-Christians are declared null and void, not valid unless duly approved by the executive authority as a matter of public policy. The evident purpose of the law is to forestall conflicts, some of which may affect peace and order that often ensue in contracts made by or with non-Christians, when they have not clearly understood the import and effects thereof. The applicable rule is Article 416. That's all. Thank you and keep safe.